We have Michael Vander and we have David Heim. Michael Vander, you may remember, presented some of the arguments, particularly the First Amendment argument, and David Heim drafted the brief on the First Amendment. I'm going to ask them hard questions, personal questions about how they and their family and fellow lawyers reacted to their defense of the Constitution and their defense of Donald Trump. You'll hear it all on The Dershow. Today on The Dershow, we're fortunate to have two great lawyers, both of whom played a very important role in the historic acquittal of former President Donald Trump when he was tried by the Senate for impeachment. And these are lawyers who basically focused on the constitutional issues, particularly the First Amendment issues. And on The Dershow, I'm going to ask them the hard questions that you want to ask them. And so let me introduce two great lawyers. First of all, let me introduce Michael Vander Veen. Michael Vander Veen. And David Heim. Michael Vander Veen, you'll remember, actually presented the First Amendment argument. And David apparently helped draft and conceptualize the argument. And so we'll hear about each of their roles. But before we turn to that and before we turn to any of my questions, I know you're both eminent lawyers from Philadelphia. Give us just a word of background about your history as lawyers. Mike, first.
I'm a criminal defense lawyer here in Philadelphia. I own a law firm with 8 lawyers, a staff of about 25. Grew up doing criminal defense work. First 6 years at 26 in California and Chicago. Came here to Philadelphia 33 years ago and have been practicing here ever since. Criminal defense, personal injury, commercial litigation, anything that requires litigation, that's what we do.
So you're a real trial lawyer, a courtroom lawyer. You're what in Britain we would call a barrister. Great. And David?
Yeah. And I have a similar practice as Mike. I'm a partner at Pochetto & Lentz here in Philadelphia. I've been practicing at that firm for about 22 years. I went to Rutgers in New Jersey. And I have a focus on defamation lawsuits. I do a lot of internet defamation lawsuits, represent victims of internet defamation, and I focus a lot on First Amendment issues in my firm.
Hey, great. We can talk about some other issues as well. As you know, on The Dershow, we talk a lot about the internet and free speech. I have a new book coming out called The Case Against the New Censorship, Big Tech, universities, and progressives. So maybe we'll talk about that at some future time. But today we want to talk about the trial in the Senate and the role you played. And so, Mike, can you first start out by telling us how you saw your role in the case? What was your particular unique function in the case?
My role changed a little bit over time, but my role was just to kind of make sure that the case was put on and that it proceeded from start to finish, whether it was what it required in the back of a trial, from everything from equipment to technology, to putting together the team members, and then trying to kind of divvy up responsibilities in the various areas of law. I really wasn't, lead counsel or anything of that nature. That was for Mr. Castor and Mr. Schoen together, I think. And then I kind of changed to some case presentation in it as well. David and I really started out on this together. When we were hired, I said, I'll take First Amendment, and I contacted David's firm, and David in particular, because he's really well known in First Amendment issues and highly respected in the city for that. So I wanted to consult with him, and I called some other folks too that I know, but David and I really sat down and first worked through a brief that needed, 10 parts put together in about 30 hours.
Yeah. And it was an excellent brief. Dave, apparently you had quite a bit to do with that brief, right?
He's really the architect of the First Amendment portion of that brief. Other folks worked on the due process. Some worked on Mr. Schoen worked on jurisdiction. And so, so parts were divvied up. David's was clearly First Amendment put together, in collaboration, but took just a massive laboring war all through, 2 late nights and, without sleep kind of stuff.
Right. We know about that. David, a little bit about your background.
Sure. Like I said before, I do a lot of defamation work. Representing plaintiffs, although sometimes I do defense work as well. But that obviously is a constitutionalized tort. The First Amendment plays a huge role in it. That's kind of my background in the First Amendment, although I've had other First Amendment issues.
So David, I'm going to ask you the question very directly. How did you feel when you saw a letter from 144 people who claim to be scholars and experts on the First Amendment accusing you of putting forward a legally frivolous argument that, if they were correct, could have resulted in your being disciplined by the bar and perhaps even disbarred because it's unethical to present a legally frivolous argument? What did you feel when you read that letter?
Well, I learned about the letter on February 5th, which is a Friday. I had been engaged by Michael as a consultant to draft the brief, I think, Tuesday before. I had done the research, I had written the brief. I was very proud of what we came up with, because when I read the House manager's brief, I was really shocked at some of the astounding legal arguments that they were making, particularly that the First Amendment doesn't apply at all, or it's totally irrelevant to these impeachment proceedings in Congress. And they were trying to treat President Trump as a civil servant, suggesting that he had no First Amendment rights whatsoever. They could simply fire him. Those I knew, having read the brief, they were totally off base. And I had already written the brief explaining exactly how, and I was very confident in it. I then saw this letter, Associate sent it to me, and I read the letter, and I really became angry, to be honest with you. Several of the professors that signed that letter were my professors in law school at Rutgers.
Right.
And I don't have a problem with professors expressing their opinion about a legal case. And that is not what made me angry. But what made me angry was exactly what you pointed out, which was the language that they used to call it legally frivolous. That is a loaded term in the law for lawyers. And I knew what that meant. Some of my partners learned about the letter, and they brought it up, and they were concerned, frankly. What about this? I think the letter was published also in the New York Times over the weekend.
Yes.
And I got articles being sent to me from colleagues. What are you doing if this is legally frivolous? And I never equivocated that I knew what I was doing was not legally frivolous. If anything was frivolous, to suggest that the impeachment proceedings shouldn't include First Amendment analysis, or that the president was like a civil servant and had no First Amendment rights, I might characterize that as frivolous.
As you know, that argument was made not only by the House manager's brief, it was made by the American Civil Liberties Union. The American Civil Liberties Union issued a formal statement. They had a vote. It was unanimous on the national board. I used to serve on the national board. I don't think I remember a single unanimous decision ever rendered by the national board of the ACLU when I was there. We were the most divisive, feisty, divided group ever. We never agreed about anything, but we always came down on the side of the First Amendment. But here you have a unanimous statement by the ACLU saying essentially the First Amendment doesn't apply to impeachment proceedings, and that the president had no First Amendment right to deliver the speech he gave on January 6th. Now, you say you had some of your professors, some of my colleagues, Charles Freed, the former Solicitor General of the United States, Larry Tribe. The person who surprised me most was Floyd Abrams, who is essentially the dean of the First Amendment bar in many ways. I worked with him very closely on many First Amendment cases, including the Pentagon Papers case. I was the lawyer for Mike Gravel, the senator.
The person that surprised me the most was the House manager, Raskin, because he was the author of their trial brief, which spent about 3 pages on it. But more importantly, he was the presenter of their argument or a contrary position on the First Amendment. So although our brief hit it pretty hard, what was really important, I think, was our presentation to the American people about what the First Amendment is, how it applies, and the steps that you have to go through in the analysis. So we really had two pieces working. We had the written piece, but then we had the oral presentation, and it was
right.
It was to a different crowd that was written to than the brief itself. So it was very interesting that the senators really needed something to grab onto and have an understanding that their constituents needed to be able to understand what the First Amendment was and why it needed to apply, particularly in the Senate chamber in that proceeding.
Right. And you basically had a jury of 11 or 12. Your job was to make sure that you held on to the 11 or 12 Republican senators who had voted no jurisdiction in the Senate, and two of them changed their votes at the end. But your job was to hold on to that relatively small jury. And I gather your strategy was to talk to the American public and have them talk back to the senators who obviously care about their constituents. Was that your strategy?
That was absolutely it. The senators needed to have their constituents understand what was wrong with this impeachment process and why you can't go forward, particularly after 14 hours of Hollywood production video of the tragedy itself, which really wasn't the issue. We were supposed to spend 2 hours on jurisdiction. They never mentioned jurisdiction and spent 2 hours on, impassioned video, that incensed everybody, of course.
Right. And
we
of course,
had to present the case differently than I think we originally would go into.
Their essential argument, the House manager's essential argument, and the ACLU's essential argument is the one that was explicitly rejected by the framers of the Constitution when a proposal was introduced to have the British system. That is, to allow the president to be removed from office like a civil servant based on maladministration. That was the word that was used. And the father of our Constitution, James Madison, rejected that. He said that would turn impeachment into allowing a president to serve only at the pleasure of the legislature. That's the British system. We rejected the British system and required the 4 criteria that we all know: treason, bribery, or other high crimes and misdemeanors. Now, obviously, you can't have treason, bribery, or other high crimes and misdemeanors if the statements made are protected by the Constitution. That seems almost self-evident that the First Amendment dominates and governs. The analogy I used to like to give is, let's assume they impeach somebody because he was a Muslim, and the Constitution says no religious test shall ever be required. Could they say, oh, no, but that doesn't apply to impeachment. Only certain provisions of the Constitution apply to impeachment, not that. Obviously, the First Amendment governs impeachment, and I thought you did a very, very good job in doing that. But you say, David, that your firm actually gave you some pushback when they heard the words legally frivolous. How did you deal with that?
Well, I've been working with the firm for 22 years. I have an excellent relationship with my partners. And I explained to them, and I sent them my brief that I had written on the First Amendment, which included, I went and found quotes from James Wilson, who was a founding father and spoke about how the Constitution, if you abide by the Constitution, you cannot be impeached. I went through the Constitutional Convention and pulled quotes out of there, some of which you just mentioned, Alan. And I said, this is not frivolous, guys. We do this for a living. In fact, I've written a treatise on the wrongful use of civil proceedings, an element of which is that there is a legally frivolous or factually frivolous component to the claim. I know what that means, more than anybody, more than most. And my partners do too. And I said, this is not frivolous. What I feel like this is, I actually cited your book now, The Cancel Culture. What I felt like before there was due process, before there was a airing of all these legal issues, there was an attempt by the media machine to squelch it, to make it seem as though these guys don't know what they're doing. Trump is trying to be canceled. They're trying to cancel Trump's lawyers. They're trying to cancel Trump's lawyers' legal arguments by characterizing them as legally frivolous without really analyzing the legal issues. And I will note that the law professor letter came out 3 days before we even filed our brief. So they didn't even see our legal arguments, but yet they were calling them legally frivolous.
Well, I think they were intending to try to frighten you out of writing that brief and try to scare you and your law firm and sending a message to bar associations. It read to me like intimidation. It's read to me, and that's why I wrote my op-ed the next day saying that as a professor of legal ethics for 25 years, let me assure the lawyers that what they're doing is not legally frivolous, and I would defend your right if you were called in front of any bar association, because I not only am an expert on the First Amendment, but legal ethics as well. And I know a frivolous argument when I see it. I've seen plenty of them. And the only frivolous argument I saw in this case is the House managers and the ACLU's argument that says that a president is like a government employee or a cabinet member. They use the analogy to a cabinet member, which the president can fire a cabinet member just by snapping his fingers. Doesn't like the way he looks, doesn't like the way he smells. A cabinet member can be fired at will. And that argument was utterly legally frivolous in every possible way, and yet it was put forward by the House managers and the American Civil Liberties Union. Shame on both of them.
If I may, I'd like to, in that proceeding, the First Amendment was abused, the Fifth Amendment was abused, and the Sixth Amendment was abused. But I really want to talk, as you're starting to now, about what happened, the chilling effect of the Sixth Amendment. As the architect of the entire brief, not just helping out in the First Amendment, but in all of it and putting it together, Mr. Castro, myself, and Mr. Schoen had our names on the brief as the submitting folks, and have had all of us, the three of us, have had tremendous backlash during the trial. Of course, those 140 law professors really weren't writing to Mr. Heim at all. They were writing to us.
Right.
And I have had a complaint already filed with a disciplinary board. I had backlash from a professional organization to which I sat in the executive committee of a small vocal group of folks. So the chilling effect on this client's Sixth Amendment right to counsel has been drastic. And when you really talk about the cancel culture, the facts of this case are that after we argued the case, from Senate Rule 23 through First Amendment due process and the actual defense of the words itself under the First Amendment as it's applied. As soon as that was done, people thought that we had certain positions, which we do or do not have. It's irrelevant. But they, the right, your Hannity's and your other shows wanted us to come on, and we came on and we really talked about what we talked about in the closing, that the left and the right need to come together and govern us more responsibly. But what happened was Cooper, Maddow, and Cuomo, none of them wanted to hear from us about the case, about what the problems are down in Washington, and the media's role in it. What they
as you
did,
know, as we speak
this
now,
is important. This is really
Congress is having.
This is really important. So what they're doing is they're controlling the information that goes to politicians, constituents, the body public. They're controlling that information in so that when the politician is in Washington and needs to come from the left a little bit into the middle or from the right and a little bit into the middle, they can't, because their constituents aren't informed. In fact, they're misinformed. They're misinformed by a media on the left and a media on the right that requires division to get their viewership, and they misinform, they control the information, thereby maintaining the division, not allowing the politicians.
No, I agree.
Possibly.
And in fact, as we're speaking now,
situation.
Yeah, as we're speaking now, the House is having committee hearings calling on the carpet only Fox and Newsmax and one other right-wing station, but not CNN and not MSNBC, talking about the flow of information. And it is, you guys, lawyers, you're great lawyers, but you're too young to remember McCarthyism. I grew up in McCarthyism. I was a president of the student body at Brooklyn College when they were firing professors and when lawyers were being disbarred for representing communists. And that's why it resonates with me so deeply. And it's so appalling to me that colleagues of mine like Larry Tribe would demean lawyers and attack lawyers who make these arguments. When I made my argument over a year ago, he refused to respond to them. He called them bonkers and nuts and crazy, using all kinds of words like legally frivolous, but he never engaged. And you guys had the courage to fight back, and I stand behind you. And if any of you have any legal disciplinary problems, or David Schoen or anybody else on the legal team, please call on me pro bono. I will be there to write affidavits, help you, because I strongly believe in the right of counsel and that professors shouldn't be discouraging lawyers from making legitimate arguments, winning arguments, arguments that ultimately prevailed in front of the United States Senate. So let me ask you this question. You've had a lot of pushback, a lot of kicking.
I hope prospective law students look at that list of 140 professors and make sure that they don't go to those schools and certainly aren't taught by those professors.
There are a lot of schools, a lot of good schools there, but the pushback that you're getting, tell us if you had it to do over again, and if you knew what the response would be, would you have been willing to do this, or do you think, on balance, this has caused you more harm than good, or good to the country? How would you evaluate your experience now, either of you?
I think my perspective is we did an enormous service to the Constitution. It's our absolute oath to do that. I would do it again in a heartbeat. We defended the Constitution in a really strong, passionate way that the American people could understand. Not from the mouth of a law professor, but from the mouth of a guy who's really just a citizen. And I think that had a really positive impact. I've had a small group of vocal lawyers who are probably haters to begin with, but overall the reaction worldwide has been tremendous in support.
Yeah.
Well, I suggest that you ought to write a book about it. When I defended the Constitution the first time around and got a lot of pushback, including from friends and family, I wrote a book called Defending the Constitution, because that was my role. That's what I did. I wasn't talking about a particular person or a particular president. I was talking about the role of the presidency, the separation of powers, the checks and balances system. And I think it would be good to put your defense speeches into a book so that it will be remembered by history and your role would be remembered. David, what kind of an impact has it had on your life and your career?
Well, I feel like on your show, Alan, right now, I'm outing myself, because up until now, I was not on the brief. I think that's what initially I preferred. I took a backseat role, even though I wrote the brief, were a big part of it, and had a big part in preparing the presentation. But when I got back home and started to realize some of the backlash that Mike and David and Bruce were receiving, not just public lay people backlash, but professional lawyers who were, asking Mike to resign or suggesting that he should resign from his board member seat. I felt compelled to come out in support of Mike and what we did. I know that it wasn't frivolous. I know that it was meritorious. And I think the public has to understand a lawyer's role in our constitutional system. A lawyer's role is not to agree with his or her client's personal political beliefs. A lawyer's role is to objectively review the facts and apply the law as we understand it to be to those facts in an objective way. And that is what Mike did, and that's what I did. And we did it in defense of the Constitution, and I feel very proud of it.
And really about 8 or 9 other lawyers all had eyes and were working on this brief and the whole case presentation. We had a really strong team of people that believed in defending the Constitution, and they all did a really, really strong job, and they should all be proud of the work they did.
No, Mike, I wonder what happened. How did you feel when one of the senators, you'll remember who it was, I don't, one of the senators turned to the defense team and said, what is your personal opinion as to whether or not the election was actually stolen? Was it you who was asked that question?
That was the question from the senator from Maryland who sits next to the junior senator from Vermont, Mr. Sanders. And he had asked a very long question about election fraud theories. And then, in my opinion, did I believe that they were true? And I said, well, and I asked who asked the question because I hadn't had a question from the Democrats yet, and I really wanted to answer the question directly. So I asked who, and the gentleman said, I did. And I said, well, my opinion doesn't matter in this, and was going to go into the First Amendment analysis again and due process violations that were present. And and Bernie screams out, yes, your opinion matters. And Senator Leahy had to hammer him down and say, you are not under the rules. You cannot interrupt and answer. Guy gets to answer. So he got hammered down. But
the idea of asking a lawyer what your personal views are.
We're a vessel for the arguments that need to be made in defending the Constitution.
Yeah, that's like asking a criminal defense lawyer, what's your personal view as to the innocence or guilt of your client? I mean, no criminal defense lawyer should ever be asked that question. I was once asked a question like that. I made a bail application in front of the Second Circuit, and one of the judges on the panel said, what is your personal view as to whether he's a flight risk? And of course, I wanted to get bail for my client, so I really basically had to respond to that question, but it was an inappropriate question. You shouldn't ask lawyers their personal views on anything involving representation of a client. So where do we go from here? There's been a tremendous setback in the Sixth Amendment. I think we are entering a world of McCarthyism. Lawyers are being attacked for who they represent. You're fighting back. Where do we go from here? What's our next step? How do we persuade the American public that the only thing that distinguishes our legal system from the Chinese, the Iranian, the Russian, the Belarus, the Cuban legal system is that we have lawyers like you, brave lawyers, standing between the government and tyranny and our First Amendment rights? How do we educate the public about that?
I think that more lawyers, and lawyers are key, because we are, in a sense, at least part of the guardians of the Constitution. And we have, as a profession, we have to stand up for things that we have shared values in. And we should all have shared values in constitutional due process. We should all have shared values in defending the First Amendment, not about the merits of what somebody says, but about the right to say it. And those things have to be stated. We cannot have members of our profession. We can't eat our own. We can't have members of our profession attacking other members for representing a client and objectively applying the laws of due process and free speech. It's wrong.
But how do we fight back? What do we do now to stop that? You know, lawyers think it's acceptable today to represent Nazis marching through Skokie. That's okay. But to represent Donald Trump, that's beyond the pale of acceptability. There's the Trump exception to the Constitution. They talked about the January exception. There is no January exception. As you know, president can be prosecuted for what he does in January. But there is a Trump exception. The ACLU created a Trump exception. The House managers, the lawyers who are going after you, they're saying if it was anybody but Trump, we would be defending you, but because it's Trump, we're not going to defend you. Do you think that's going to end now with the end of the Trump presidency, or is it going to continue and get worse?
Well, I think he'll, it's obvious people are continuing to want to prosecute him for all kinds of things. But to answer your question, what do we do going forward? One, we continue doing what we've always been doing in the courtrooms every day, defending the Constitution and holding to our principles. But we also I have to now take what I've learned down there about how the system is broken, how the media plays a role in that, and as much as possible, educate the people as to what's going on, try to put sunshine on a bright light on what the mainstream media is doing and how they're trying to how they control the information, and urge everybody to come with a spirit of compromise, moving from closer to the middle to govern in all of our shared national priorities. And I don't need to go through those now, but they're very important shared priorities.
Let me ask you one final question before we have to close. Let me ask you a personal question. I know in my case,
New York Times, for example, before this ever happened, I would never have thought of doing that. But it's important for me to tell everybody, as many that will listen, what I learned and how dangerous it is and how it needs to stop. And you have to call them out. You have to call them out by their name, that this is what they're doing. You have to.
I agree. And one of the reasons I agreed to do this podcast, I'm a busy guy, is because on the Dershow, we get exactly what you're calling for: a movement toward the center, the defense of the right to counsel, nonpartisan defense of constitutionality. I want to end with a personal question to both of you. I know when I was in front of the Senate making the arguments like you made a year earlier, it affected my friendships. It affected some of my family relationships with me. And it was very upsetting, obviously, because I've been doing the same thing for 65 years. I've done nothing different, but it's now on behalf of a very unpopular president. What impact has this had on your friendships, on your personal life, on your family lives, if you're prepared to share that with my audience?
Well, I've had family members who I don't think understood what I do for a living, even though I'm a lawyer. And I had to explain to them that I'm a lawyer and we apply the law evenly to everybody in this country. And if we don't do that, it's a danger to all of us because it's a slippery slope. And I had several conversations like that. And I am doing this not just for Donald Trump, but for all of us. And they started to understand that in my family. But Good. That conversation.
Good. And
for me, I mean, it's kind of well known in our circles already, so didn't have much of an impact other than my daughter Emma Rose has me in her phone under GOAT, and she said, Dad, now the whole world knows you're the GOAT.
Goat has multiple meanings. So the Brady goat, greatest of all time. Right, or the goat. Well, you guys are heroes. You stood up at a time when few lawyers were prepared to stand up. You took a lot of the brunt of the attack. You fought back. You did a great job in front of the United States Senate. And in the end, you won. And you won not only for former President Trump, you won for the Constitution, you won for the rule of law, you won for the right of people to have counsel defend them. And so I just want to congratulate you on a job well done. I want to thank you for coming on the Dershow. You're invited back if you come back on any other issues relating to the First Amendment or the right to counsel. The Dershow is always open to different points of view. We will have people calling in about your comments. Some will agree, some will disagree. But now at least you've heard from two of the most prominent lawyers who defended the Constitution on behalf of Donald Trump. And I want to thank you very much for being part of this show and being part of American history. Thank you. You've heard now from two of the most important lawyers who defended the Constitution and defended Donald Trump against unconstitutional charges, which resulted in a trial in the United States Senate. Now I want you to weigh in. What did you think? Did they make a good case? What did you think of their reaction? What did you think of the 140 law professors who tried to dissuade them from making a First Amendment argument? I want to hear from you on the Dershow. I want to hear your comments. I want to hear your questions. I want you to tell your friends to subscribe to the Dershow. I want more and more questions, more and more comments, more and more dialogue on the Dershow. An important part of the Dershow is your voice, your questions, your comments. Please call 24/7. The number is 216-710-0050. Keep your comments short and to the point. Again, the number for you to call 24/7 is 216-710-0050. Hard questions, criticisms, everything's fine. Just keep your questions short, and I'll answer them all on the Dershow.